Hello, everyone, and welcome to Asurint's monthly webinar series. We're just waiting a few moments to give everyone a chance to join, and then we're going to get started. All right, let's go ahead and get started. Welcome to Asurint's latest webinar, Keeping Up with Compliance, Legal Updates for Q2 of 2025. Today's expert presenter is Asurint's General Counsel, Kelly Uebel. Kelly will be introducing herself in just a minute. So before we begin, I just wanted to give you a quick introduction as to Asurint, in case you're not familiar who we are. Asurint is innovating the background screening industry. Our powerful, customizable technology, backed by subject matter experts and personalized assistance, help you hire the right candidates every time and faster than ever before. With us, professionals like yourselves leverage faster background checks to reduce manual workloads, minimize compliance risk, promote a safer workplace, and drive insights that boost hiring and recruitment success without sacrificing comprehensive, complete records. A few quick housekeeping notes for today's webinar. We'll probably run for about 50 minutes. And we're going to include additional time at the end for questions. So feel free to submit your questions via the Q&A function, or you can enter them into the chat and we will tackle them at the end. And then finally, as a thank you for joining us today, you're going to receive a link to this webinar recording and a copy of our popular guide, 50 State Guide, Employment, Hiring, Background Screening Laws. This guide is a very broad survey of laws across the U.S. and is periodically updated by Kelly and her compliance team here at Asurint, and is an excellent resource for you to share with your colleagues. And with that, thank you, Kelly, for leading today's webinar, and I'll hand it off to you.
Great. Thanks so much, Catherine. Welcome, everyone. Thank you for joining us today. As mentioned, Kelly Uebel, General Counsel for Asurint. I've been with Asurint for 8 years as of this month, so celebrating my 8-year anniversary here, and I've been in the industry for 14 years. I've previously served on the board of directors, including as chair for the Professional Background Screening Association, or PBSA, and remain actively involved in the association and government relations efforts, serving on the tenant background screening subcommittee, leadership development committee, and finance committees as well. So background screening is my passion, compliance is my passion, and really excited to kick off the discussion today. Before we begin, a quick disclaimer. This information is educational information only. Nothing I say here should be thought of as legal advice. So you'll probably hear me say a million times throughout this presentation, as I always do, that I highly recommend you work with your legal counsel on anything we talk about today and anything to do with your program. In terms of an agenda, it's going to look very similar to past compliance quarterly webinars. We are going to have an agency and legislative update, and that's where we're going to spend the bulk of our time today, because some states were rather active over the legislative sessions that they've recently had. A lot of states are already out of session, but certainly some state and local activity I want to highlight, as well as federal activity on the agency side of things. Then we'll kick over into a litigation update, some interesting cases to highlight there today. And then we'll close with marijuana legislation and litigation. Not as much to cover in terms of marijuana today, but there is a really interesting case from Pennsylvania I do want to talk about. As Catherine mentioned, if you want to submit any questions throughout, feel free to use the chat or Q&A feature. I have both of them up. I try to stay somewhat engaged with those as we go along, in case I can address your question real time on the topic we're covering, but we will have time at the end. And if we run out of time, I will follow up with you via email to address anything left unanswered as well. Okay, so let's start with agency and legislative actions. We're going to start briefly here with Form I-9. Just in case you haven't come across this yet, the USCIS did publish a new version of the Form I-9. It's available on the government website. It has an edition date of 1/20/25. And as noted on the USCIS page there, you can still use the previous editions. Those are listed on the screen with the edition dates and expiration dates. Just make sure that if you use any sort of electronic system to send out a Form I-9, you're working with that provider to make sure they're going to update your form, or if you have to take any action to update the form, if you still send these out via more of a paper-based process, now is the time to start looking at updating the form you're using. So just wanted to make sure that this was top of mind for everyone. All right, let's start with some agency activity. So the EEOC has been interesting. So if you remember, if you happen to attend the Top Trends webinar in January or read the Top Trends white paper, I made some predictions in that were immediately disproved, I will admit. And I covered a few agencies, including the EEOC. And my thoughts at the time were that the EEOC would retain its Democratic majority until 2026. And so we'd probably see a slower evolution of changes. And that is clearly not how things went down with the EEOC. I think it was literally maybe the next day or two that 2 Democratic commissioners were fired, which is a practice that hasn't happened in the agency's history when parties have changed hands, which is why a lot of people thought it wouldn't happen here. So the majority was eliminated. It left the EEOC without a quorum, which means they can't engage in any sort of formal actions. Now, the EEOC field offices, certainly they're continuing on with their investigations. There's still litigation work, casework happening with the EEOC, but they can't really issue any sort of formal actions. Now, where the EEOC has really shifted its focus, and I'm sure you've seen some of the joint releases it's put out with the DOJ, for example, on DEI initiatives. That's obviously been a huge talking point since President Trump came into office. Focus on gender identity. We may see some action on some of the Pregnant Worker Fairness Act initiatives. And about a week or so ago, President Trump did put forth another individual who's an assistant U.S. attorney in Florida. So if this person is confirmed, this will reestablish a quorum. It'll reestablish it as a Republican majority. So we're going to have to wait and see what the EEOC decides to tackle and how they approach it. But I think it's pretty clear some of the focus areas of the EEOC now are a bit different than what they were under President Biden's administration. And as an extension of that, what another interesting development, one of the many executive orders that have been issued was one recently where President Trump rejects the use of this disparate impact theory of liability. And we've talked about that in the past. It's leveraged by the EEOC, in particular in the context of criminal background check lawsuits that they have filed. And I pulled one of the quotes from the executive order on the screen there that he feels this theory runs contrary to equal protection under the law and therefore violates our Constitution. And so as part of this executive order, he's directed the Attorney General and the EEOC's chair to assess pending investigations, civil suits, positions taken that rely on a theory of disparate impact discrimination. And so something interesting certainly to track. Now, we may end up seeing an amended approach by the EEOC on some items, again, including some of the claims and allegations they've made in the past when it comes to criminal background checks. This theory was part of their 2012 guidance. It's been around for a long time, this concept. And thus far, their most recent lawsuit that was filed last April against Sheets remains active. It's worth keeping an eye on. Don't know how that will continue to develop. But one point I want to make on this item here is I've read several articles published by various law firms on this executive order and just this concept generally. And they make an excellent point that this executive order isn't going to put an end to private litigants making these kind of allegations against private employers. It's not going to put an end to pursuing these types of claims in state courts, where states like California, Illinois, New York, Minnesota, these states all include this theory in their state laws, right? And some of the early litigation activity we've seen on the artificial intelligence front has also pulled in this kind of concept of disparate impact liability. So we're seeing its expansion, certainly beyond criminal background checks. And so this is a great place. Check in with your legal counsel, see what their thoughts are, how it may impact your program and processes, if at all. Maybe it's just more of a less of a threat on the federal level than it used to be, this kind of theory. So certainly worth a discussion, and to obviously keep tracking this as well. All right, criminal history. We have a few updates in the criminal history section. So I'm going to start with Washington. Washington has amended its Fair Chance Act, and you can see there that it takes effect at different times depending on how many employees you have. So if you have 15 or more employees total, this will go into effect July 1st of next year. And if you have less than 15, not until January 1st of 2027. So the good news is the state has given you quite a ramp period to look at what you're doing and to make adjustments. And the Washington Fair Chance Act has been around for a number of years at this point. So it's certainly not a new concept, but it is definitely has a number of amendments to take into account. So a few of the highlights here: it does create new definitions for adult conviction record as well as arrest record, and pending cases are included in the definition for arrest record. And there's a limited carve out to the prohibition on use of this information. So we're still evaluating whether or not pending cases should remain reportable in Washington. So if you're a current client of ours, stay tuned. We do plan to issue pretty comprehensive client communication in short order here, and we'll have more information about that as well. Some other highlights: you can't do a criminal background check until after a conditional offer. That's very common now in these more extensive fair chance laws. We've seen it in other states like California, for example. So that shouldn't be too big of a surprise for employers. You can't use arrest records or juvenile records to carry out any sort of tangible adverse action. And again, this applies for applicants and employees. So, rescinding an offer, terminating an employee, suspending them, disciplining them, it covers a pretty broad spectrum of what could be considered a tangible adverse action. And speaking of adverse action, one of the big impacts is really on this process. So prior to taking any sort of tangible adverse action, and I keep using that word tangible because that's the full phrase from the law. So definitely review the law in its totality for the definitions of all these items. But before you can move forward with making any sort of adverse decision, you have to look at ensuring you have a legitimate business reason to do so. Again, common terms that we see across these fair chance laws. So you have to do a specific analysis to get to that resolution. So you have to really look at, is there a negative impact on their ability to perform the position? Will they cause harm potentially to people, property, reputation? And have you considered a variety of factors like the seriousness of the conduct, the number and types of offenses, any verifiable information related to their rehabilitation, good conduct, work experience, education, training? So anything that the individual may provide you on that front. As well as the place and manner in which the position will be performed. So some of the factors that Washington is going to require you to go through do deviate a little bit from other fair chance laws that outline specific factors. So again, good to spend some time looking at exactly what you need to consider and what you need to document. And documenting this analysis is going to be really important for step 2. So after you've gone through this process, You can then notify the individual. You have to identify the record, the information that's at issue. We've seen that again in other fair chance laws. And you have to hold the position open for a minimum of 2 business days. Note that this is different than the waiting period. So they want to see you actually hold the position open for at least 2 days. They don't tell you how long you need to wait between your letters. So between sending this pre-adverse action notice and then the final adverse action notice if your decision becomes final. So just an important distinction there. Now, after that time period expires, you have to provide a written decision if your decision is going to become final, including your specific documentation and assessment that you went through to the individual. So you actually have to provide that to the individual. And so really going to be important to track whether or not the state hopefully will issue some sort of samples for this. They have some time to get that together. In jurisdictions like Los Angeles City, New York City, we saw those cities issue sample assessment forms to be leveraged. So hopefully we'll see that in Washington as well. So really, this is going to impact your adverse action process. One other caveat to this law that's a little bit different than some other fair chance laws we've seen is that if an individual voluntarily discloses criminal history information to you, you have to inform them of the requirements of this law, as well as provide them with the Attorney General's Fair Chance Act guide that is available and I'm sure will be updated. So again, something new, something different, hopefully some more guidance and samples to come from the state. But start thinking about this law now, even though you have a little over a year to make some updates to your process, which is great. Usually we see a much shorter time period for you to have to come into compliance. So this will be great. I do see a couple questions coming in the chat on this one, including, does this include a written assessment similar to California? Yes. So you will have to provide your assessment, your documentation on your reasoning, which includes going through those factors, that specific analysis to the candidate with the final letter. And so that is really going to involve a little bit more interaction than you may normally have when it comes to issuing that final adverse action letter. In terms of how this is different from California or Illinois, that's a really tough question to address right here on the fly, but a lot of it's the same. So you have across these fair chance laws in states like California, Illinois, New York City, you're seeing a lot of the similar factors that you're required to go through and do and consider, like age of the applicant, nature of the convictions, evidence of rehabilitation, things like that. So it's a much more engaged and individualized process in these states than in states without these particular laws. Illinois, for example, requires you to identify the record at issue. They also require you to provide your reasoning. So it's kind of a double item you have to do in Illinois versus Washington and California is more identifying the specific record. So there are some similarities, a couple tweaks and differences. We will be updating our 50 state guide as well as our ban the box guide to reference this new Washington law. That will be done in short order here. So recommend going to the site in a few days where you can pull the updated versions of those guides. And especially the ban the box guide, you'll be able to do a really pretty high level, easy comparison across the states that you're most interested in to see how they are the same and how they differ. Okay, let's move on to Minneapolis. So Minneapolis in Minnesota, my home state, I always have to give a shout out to Minnesota. They recently passed a discrimination ordinance to amend their civil rights law. It was signed by the mayor and it goes into effect August 1st. And so according to the act, rather than using criminal record status or criminal history as the definition, they include this term justice impacted status. And this is defined to include having any sort of criminal record or criminal history. It includes arrest, charges, convictions, period of incarceration, past or current probationary status. So it's a pretty broadly defined term. And this will impact your use of this information from an adverse action standpoint. So if you're considering taking some sort of adverse action based on this information, again, what we just talked about in Washington, you have to look at a lot of factors and do an individualized review. So you have to look at things like the relationship of the underlying conduct of the criminal history to the ability and fitness to perform the position, whether it actually was a conviction, the nature and gravity of the offense, if there's an unreasonable risk to property or safety, evidence of rehabilitation. So now you can kind of hear some of these common themes we're seeing in these new fair chance laws. And so, which is great, right? Because then you can hopefully have more of a standardized, individualized assessment process. But it will be important to go through this ordinance if you're impacted by it to pull the full list of factors you need to go through. It does not speak to having to provide that assessment or analysis to the candidate in any capacity. Of course, always a good idea to have this documented and in writing in case it becomes an issue so you can easily point to it versus trying to remember that you did it and what you considered. A great thing to talk about with your legal counsel in general is just your approach to individualized assessments, how you document that information, how you're conducting the process. That's really important. And we're going to see in the litigation section that's really important, especially in places like California. And so, again, really looking at that individualized review, individualized assessment here. You cannot use arrest only information to make a decision, but you can consider pending cases. So a big distinction there. And we are continuing to see more and more cities and states address arrest only information and prohibiting employers from leveraging that in their decisions. And there's also a lot of other items covered in this ordinance that, while may not be pertinent to our conversation today, just want to quickly highlight for you. So height and weight discrimination is covered, pregnancy related accommodations and leave is covered. So certainly if you're in Minneapolis or have employees in Minneapolis and are covered by this law, definitely spend some time on the ordinance because it is a bit more expansive than just touching on this justice impacted status. Okay, really quick, want to touch on one question here. So if you're doing a criminal history check on a new hire in Virginia, let's say, that's maybe lived in Washington or Minnesota, would these laws affect those states or counties searched or conducted? So before I answer, of course, run this by your legal counsel. I've always personally looked at it as where is the candidate living or working? So if they are living and working in Virginia, where they're going to be able to sue you is arguably Virginia. So you want to look at Virginia law. So even if, let's say, they used to live in Washington, the Washington Fair Chance Act is going to cover folks living in, working in Washington, not living in, working in Virginia, even if they have prior history there. So it doesn't necessarily impact where you can search, how the searches are done. It really is looking at which laws may apply to that individual person, and which laws do you need to be mindful of. A good example is on the East Coast, they may be living in New Jersey but working in New York City. And so that's a consideration because then they may be under the scope of the New York City Fair Chance Act, even though they're not living there. So really important to look at those two items. Really important to work with your legal counsel on what laws they think should apply to your individuals. So really, really good question. Okay, Utah. So we don't talk about Utah a lot, but here they come. They passed Senate Bill 70. It did go into effect May 7th. And it amended the state's existing law to prevent consumer reporting agencies. So that's really the term of art for companies like Asurint, background screening companies. We're called consumer reporting agencies, or CRAs, if you ever hear those. That means background screening company. And so it prevents us from reporting things like arrest not resulting in conviction. There you go, that arrest again, arrest prohibition. Criminal charges not resulting in a conviction, and expunged and pardoned convictions. CRAs can report pending criminal charges and arrests that have not yet received a final disposition. Asurint, as a standard, only reports pending cases and convictions. We don't report non-conviction information such as arrest only, dismissed, sealed, expunged cases. We do report pending criminal charges unless we are told we cannot by some sort of law, or the employer does not want to receive that information. So just as a standard, that's kind of has been our approach for quite some time now. On that, if you don't use Asurant, check in with your screening provider on what their criteria is to make sure they're aware of these laws and they're updating their reporting accordingly. They should be able to give you some documentation on what they do. And if you're interested in that from Asurant, we have that ready to go. So if you're a client, feel free to reach out to us and we'd be happy to give you more details there. All right, going to switch gears a little bit, talk about everyone's favorite topic, AI, the topic that everyone talks about, but I think a lot of people still don't fully understand, which is totally fair because artificial intelligence covers a broad amount of information, right? And sometimes people say they use AI when maybe it's not really, it's just a messy area. And it's getting messier from a legislative and regulatory standpoint because on the federal level, this isn't even on the radar really for people to talk about. So when we were at our last PBSA conference in the spring, we do what we call Advocacy Day, and we go into various offices of senators, representatives on the federal level. And one of the topics we talked about was AI. And so I met with people from Minnesota, Wisconsin, Pennsylvania, and the responses were basically all the same. There's a lot going on the federal level right now. They're just trying to get their arms around what's happening. And AI is so far down the priority list, and a lot of members don't fully understand it, right? And so AI and data privacy is just not going to move forward anytime soon on the federal level unless something dramatic changes, because they just have a whole host of other things to focus on. So what we see in the absence of a federal standard is, of course, state activity. We've seen it on the data privacy front, where a number of states have passed various data privacy laws that, of course, don't all align. So you're dealing with several different standards depending on how many states you operate in. And we're going to see that on the AI front now as well. So we've seen a couple states already pass legislation on this issue. Illinois, Colorado, a couple examples. California is very active right now in looking at regulations on AI. So the Civil Rights Council did finalize its regulations. They're awaiting review by the Office of Administrative Law. And they really focus on and include several definitions for things like automated decision systems, algorithms. So it's important to review the regulations for the actual definitions, but really they're focused on using automated decision systems to discriminate against an individual based on any sort of protected classes. And so really looking at, again, removal of the human from the process. So resume scanners, any sort of interviewing type tools. There's a broad range of things that they cite as examples in the regulations. They do point to the fact that if you conduct things like anti-bias audits, or you have some sort of other evaluation criteria that can show that this isn't resulting in discrimination, that can be used as a potential defense. And it also updates the criminal history regulations through the Fair Chance Act, where pre-offer you can't consider criminal history through any sort of automated decision system. So previously that included an employment application, background check, internet searches. So basically you can't really do anything with criminal history pre-offer in California. Quick pause. I see someone raised a hand in the Zoom. So we don't take live questions via voice. So please go ahead and put it into the chat or Q&A. And would be happy to address. So again, important to look at the definitions. It's a good time to start doing almost a cataloging or an evaluation of what tools you're leveraging in your hiring, recruitment, and employment processes. Which of those are from a third party? Which of those may be homegrown? And start thinking about what discussions you want to have with those third parties or internal parties as to how AI is actually leveraged in the systems. Are they automatically kicking out resumes? Where does automation come into play in the background screening process? And is there any level of automation or any potential for algorithmic discrimination? That's the other really popular buzz term right now. That kind of entirely removes the human element and may make you vulnerable to discrimination claims. So now is a really good time to start doing that. And there's separate regulations in California being considered as it relates to the Consumer Privacy Act. So competing regulations potentially. Senate Bill 7 was introduced in California to address this issue. We've seen states like Texas and New York introduce legislation on AI. So again, it's a hot topic. It's only going to get more popular for states to address. They're kind of struggling with how to address it. A good example of that is Colorado. They passed this AI bill and then realized, oh wait, we did some things we didn't mean to do. We included some items we didn't mean to include. Their efforts to amend the law did fail this legislative session, but I think they're still trying to address some of the deficiencies in that legislation before it goes into effect. So again, it's going to be kind of a trial and error system, I think, on the legislative front, but really important to start looking at the tools you're using and how they may or may not become an issue for you as these laws and regulations continue to advance. All right, moving on to clean slate and expungement laws. So Maryland SB 432, it was signed by the governor in April and will go into effect later this year. And then another piece of the legislation will go into effect in January of next year. It does modify several aspects of the state's petition-based system, petition-based expungement system. So this isn't a clean slate law, really. It's more of a expungement law, but it does prevent the courts from disclosing possession of marijuana cases if a pardon was granted, and that'll go into effect in January of 2026. So we are still seeing a lot of states look at not just the expungement overall, but certainly how they can lessen some of the problems caused by these lower level marijuana offenses, particularly as marijuana continues to get legalized both medically and recreationally. On the clean slate side, we did see several states introduce legislation, but really what we've seen is states with this legislation struggle. So, for example, Virginia's law was passed in 2021, which already feels like a lifetime ago, right? And so they were supposed to start implementing the automatic expungement process in July of this year, but they've had to delay that to January 1st in order to give court clerks more time to basically get the eligible cases into this new database they're building in order to start executing on the expungements. Connecticut, great example. If you Google Connecticut Clean Slate, you'll be bombarded with news articles about how this has been managed and how it has not gone well in the state. They are now targeting fall 2025 to hopefully resume their automatic erasure efforts. They received an additional or $10 million in state bond funding. And again, I've read several articles about this, and one of the people kind of responsible for leading this effort billed it as being the most complex IT project the state has ever tackled. And so these laws are really difficult for states to execute on and I should back up really quick. Clean slate really is referring to automatic expungement of certain criminal records at certain time periods. So that's what we're talking about when we talk about clean slate. But it's really hard because the courts in the states don't all talk to each other. They don't necessarily communicate effectively into the statewide system in a lot of instances. And so what we've also seen is cases getting expunged in certain parts, but not other parts. And so we're really going to continue to still see struggles from states on implementing these laws. California is getting implemented soon. New York has started to work through their law. So really keep an eye on how these laws may lead to potential delays. Certainly, once records start to get expunged, especially in a state like California, where it's, I think, 1 year for misdemeanors, you become eligible for automatic expungement, you're going to start to see like a lower hit rate as well, potentially. So, certainly, if you have more questions about how this may impact your background screening process and criminal searches, feel free to reach out to us. Happy to share some additional information. The last update here, I told you we're going to spend a lot of time on legislation today. So the last update is again out of Washington, and I can never say the city name right, so forgive me. It's on your screen. I will admit ignorance on how to correctly pronounce it. But they passed what's being called the first of its kind in the nation, a ban the address ordinance. And so whether or not this gets picked up as a concept, unclear, of course, when you're the first. You kind of set a tone. But this ordinance prevents discrimination against an applicant based on the address they give you during the application process. So you can't reject or disqualify someone solely because they don't have a fixed or regular address, or if they're homeless or unhoused, they live on the street, they have a shelter or temporary residence to give you. You can't use that in any way unless you have a legitimate, it's legitimately related to the primary duties of the position. Now, you can still collect the mailing address or means to contact applicants. So we're not reading this as go rush out and scrub your employment applications of collecting a mailing address. It's you can't use that to then discriminate against them because they may not have stable housing or something like that. So again, new concept, new law. This city does have a fair chance law already on the books as well from a criminal history standpoint. So again, once you see one city start to do something, you may see others follow suit. So a new trend to kind of stay on top of. And as noted on the screen, this does go into effect in about 10 days on May 25th. All right, let's shift gears to, oh, thanks. Someone put it in the chat how to say it, so I appreciate that. Spokane. Thank you. So let's switch gears to litigation on the disclosure form. So we're continuing to see Fair Credit Reporting Act or FCRA related claims, including on disclosure forms and adverse action, only covering one FCRA case today. And this settlement was actually rejected by the court. It was a pretty healthy settlement, 1.275 million. The allegations included that the disclosure violated the clear and conspicuous requirement, as well as the standalone requirement. So it has to be a document consisting solely of the disclosure. They're claiming that because it included state notice information as well as a hyperlink to at least one website that had nothing to do with the FCRA. So again, sidebar, make sure you're reviewing your disclosure forms on a routine basis. The settlement class was over 29,600 people, and it was actually a pretty long class size, spanning 2014 to 2022, and each person would have received around $25. And so, it goes to show these settlements for a lot of money, the actual consumers aren't necessarily getting much. I wager there's a healthy amount going to attorney's fees. But what happens in class settlements generally is that for any funds that aren't collected by the class members, they go into a particular fund, which is used to then distribute these unclaimed funds to wherever they say it should go. And so the parties here selected the Alliance for Children's Rights, which sounds great, right? I don't know anything about the organization, but children's rights, let's support it, yay, as a recipient. But the court said, look, there's no driving nexus between this association and the class or the objectives of the Fair Credit Reporting Act. So for that, denied the settlement agreement approval. The parties have to go back to the drawing board and retool this one a little bit. Next is Wisconsin, another state we don't talk about often, much like Utah, but would love to talk about here today because they've had a Fair Employment Act for quite some time. And I don't think it receives as much fanfare as like a California, Illinois, New York, but it is a really important law if you hire and employ people in Wisconsin to understand. And one of the parts of this law is that employers cannot refuse to hire individuals based on an arrest record unless those charges are still pending. And so the case here involved two employees being terminated who then filed suit claiming that the employer did so in violation of the law because it used arrest record information to make the decision. And so these people had been cited for municipal theft violations, which are non-criminal offenses in Wisconsin. And so the Wisconsin Supreme Court took up this case, really looking at how should arrest record truly be defined. So there's an actual definition, and it includes the phrase any other offense as part of its definition. So does that mean criminal offenses, or does that mean criminal and non-criminal offenses? And so the court again looked at that and decided based on a number of factors, including the fact that you can be arrested for non-criminal offenses in Wisconsin, that this should definitely include criminal and non-criminal offenses in the definition. And so these individuals were never charged with a criminal offense, never convicted of anything. I think that the citations were even dropped or dismissed. And so the court decided, okay, this was definitely arrest record information. Now let's look at what did the employer do with it. So the employer conducted their own internal investigation. And after that, they didn't terminate them based on that internal investigation. The court determined they really leveraged these municipal theft citations, learning about them, because this case all arose when someone claimed that they were stealing. So that's what prompted the internal investigation. And so since the employer really just leveraged their knowledge of these non-criminal offenses, this arrest record information, they then violated the Fair Employment Act by committing arrest record discrimination by terminating the employees. So really interesting case. There's tons of articles about it. We have a blog post going up about this soon as well. I put the case citation there in the bottom of the case name. Just as a quick reminder on this law, conviction records are also addressed. So in Wisconsin, to use conviction records, you have to make sure they're substantially related to the particular job. And so you really have to perform that individual review and analysis on a per job, per record basis. So that concept of an individualized assessment has long been alive in the state of Wisconsin. So if you hire at all in Wisconsin and you haven't heard of the Fair Employment Act, definitely worth a review. There's a lot of great resources Wisconsin publishes on it. So check that out and make sure you're looking at your processes accordingly. Finally, two California actions by the Civil Rights Department. And we talked about this in the Trends white paper and the Trends webinar. The California Civil Rights Department is all over the Fair Chance Act. I've talked to a number of employers who have been contacted by them. They are all about the Fair Chance Act enforcement. So if you are doing anything in California, make sure you're reviewing your Fair Chance Act compliance. Legal counsel review is immensely helpful for you here. Training is going to be helpful. And so I want to just include a couple of these examples. The first is a $100,000 settlement with a nationwide trucking company. This is from April. And this really arose after the candidate alleged they were rejected from the job based on criminal history, and specifically that the offer was withdrawn without the employer going through the individualized assessment process. So in addition to the $100,000, the company agreed to make sure they're performing individualized assessments, as well as provide Fair Chance Act training annually. It has to be at least 2 hours every year. They have to provide this training to their staff. Conduct a review of company policies to ensure compliance with the Fair Chance Act, and report changes to the Civil Rights Department within 45 days. So if they change their policies, they have to tell the CRD about it. Another settlement was just announced in May, so a few days ago, where a staffing agency entered into a settlement with the CRD following allegations that they impacted someone's ability to go to work for work opportunities. They allegedly didn't provide an opportunity for the applicant to provide evidence of rehabilitation or mitigating circumstances. That's an important part of the fair chance process in California. And they also did not look at whether the conviction was related to the job or perform individualized assessments. And so the individual was compensated for lost wages and other harms. I don't recall seeing a specific dollar amount in the press release. And the CRD makes all of this very accessible on their website. So if you just go to their website, look at news, interesting cases, they have a whole bunch of information on what they're doing with employers. But so you have the lost wages and other harms. They also had to agree to provide training. They agreed to update their pre-adverse action notices to include legally required information. So if you're in California, you have impacts to your pre-adverse and final adverse action letters at the state level, as well as if you're in Los Angeles County and San Diego County. So Asurint has California specific samples we're happy to make available. If you don't use Asurint, certainly work with your provider to see if they have samples available. There's also samples the CRD makes available on their site. So a good place to spend some time is on your adverse action letters themselves for California. And they also have to submit policies on conducting individualized assessments for the CRD's review. So again, a lot of oversight and a lot of enforcement on the Fair Chance Act in California. Okay, marijuana, we finally got there. So not a lot happening on the state level from a legislative standpoint. I included some examples. We saw a number of bills be introduced in the past legislative session for many states. For example, Florida, as I noted on the screen, 4 separate bills introduced. They all ended with a status of indefinitely postponed and withdrawn from consideration. So clearly not going anywhere. Hawaii's recreational efforts are dead for the session. As noted on the screen, several other states, including Tennessee's another example, didn't advance any of their proposed legislation. Poor Wisconsin, they try year after year to join Minnesota in legalizing marijuana, but the Republican-controlled legislature in Wisconsin voted to remove the medical and adult use marijuana legislation that the governor had included in the budget proposal. So that's been defeated again in Wisconsin. So we're not quite seeing that explosion in legalization legislation being successful that we've seen in the past. Doesn't mean it can't happen. Pennsylvania has advanced their bill through the House. I believe it still has to go to the Senate. But so we may still see some activity yet, but it really hasn't been the big legislative event that it has been in past years at this particular point. However, what we are seeing is plenty of litigation on the issue. So I don't think a week goes by where I'm not getting any sort of alert about an employer getting sued over what they did with a positive marijuana drug test. And we've seen this across the country. Pennsylvania has been very popular. We've talked about New Jersey. We've talked about Florida. It's really been very widespread. So this particular case from the Western District of Pennsylvania is very interesting because we've seen more cases in Pennsylvania on the state level. And so now we have a federal court weighing in on the issue, which is certainly worth noting, especially if you're drug testing for marijuana in Pennsylvania. So this really focused at the Medical Marijuana Act, the MMA, in Pennsylvania, as well as claims for disability discrimination for a failure to accommodate in violation of the Human Relations Act in the state. And so just from a brief fact standpoint, the employment offer was provided for, I believe, like a project engineer position or something like that. It was contingent on a successful pre-employment drug test. The plaintiff was diagnosed with anxiety, depression, ADHD. They were a certified medical marijuana user to help treat these symptoms in addition to a few other prescribed medications. He notified the employer before the drug test even happened. Hey, I take these medications to treat these disabilities. I am a medical marijuana card holder. Of course, goes through the drug test, comes back positive for marijuana. The offer was then revoked. And prior to the offer being revoked, it's a pretty interesting pattern of what happened between this individual and the employer, but a couple items like his prescription provider gave information about his prescription. He proactively said, hey, I'll even sign an agreement confirming I'm not going to use cannabis during working hours. And the employer's like, no thanks to any of that. You're not going to work here. So of course, the individual filed suit. And looking at the MMA first, the court denied the employer's motion to dismiss. So sufficient facts to allow the MMA part of this claim to move forward. I put a quote there from the court that the MMA would be quite toothless if it only protected just the actual possession of a card versus the use of medical marijuana. So to allow this dismissal to go forward, the court felt like it would be pretty much gutting the MMA from a person protection standpoint. So again, it can move forward through litigation. As for the Human Relations Act claim, and we've seen a lot around requiring accommodations. Is that truly required on a state level or not for medical marijuana? And the court in this case determined that the Human Relations Act does not require accommodations for the use of medical marijuana. The law specifically cites to the Controlled Substances Act, for example, since marijuana is still illegal on the federal level. We've seen a lot of courts in other states do a similar analysis when it comes to requiring accommodations. And so the MMA also does not require accommodation for medical marijuana use. So the court really decided, hey, this is not required of an employer here. Again, the federal court looked to various state court decisions for guidance on this issue. Really interesting case read. Highly recommend looking at some articles about it as well. Definitely, of course, always worth a discussion with your legal counsel if you're still drug testing for marijuana in Pennsylvania. And I put the case citation there for you as well. So again, a lot of litigation on marijuana, not as much legislation at the current moment, always subject to change. But really important to be looking at how you're drug testing, if you're still drug testing for marijuana, how you're using that information. Do you want to still test for it or not? Of course, if you're safety sensitive and have obligations to test, that outweighs anything we usually talk about, but definitely becoming a more complex landscape for employers. All right, with that, we have reached the the question and answer session of today. I said California because I've seen a few questions on it. Catherine, I'm probably just going to scroll through and kind of tackle a few of these here that I haven't already. And I do see a number of questions about California positive tests for THC and what should they do about it. So I am going to punt that and say that you need to talk to your legal counsel because it is such a tricky law in California as to how you can test for marijuana and then what you can do with those results. A similar law exists in Washington. And so I think that warrants legal advice, and that is not something I can give. So I think really recommend reaching out to your legal counsel on that issue. We do have some educational resources about the California law that I can certainly follow up and send you. So I will do so. But I can't tell you what to do with those results. Okay. Scrolling through, I actually think I've tackled pretty much all the questions that came in as we went here. So if anyone has any additional questions, feel free to frantically type them into the chat, and I'd be happy to take them. Otherwise, certainly happy to follow up with anyone via email if you have any questions that come up after the webinar. As mentioned, you will receive a copy of our 50 state guide. I'm working on updates today to reflect content that we talked about, so you'll have the latest and greatest when it hits your inbox. And so stay tuned for that. And as mentioned, some of our other guides, like the Ban the Box guide, will also be getting updated in relatively short order. So for sure, check out the website. And just want to say thank you all so much for spending some time with me. I know things are busy. If anything comes up after this, feel free to reach out, and I hope you all have a great rest of your day. Thank you.